To understand, the Attorney General is currently before a joint committee of the Finance and that of Housing of the National Assembly, and of course is making his presentations towards the Affordable Housing Bill 2023. Let's get to listen into the propositions that the AG, that is Justin Muturi, is making before the committee.
But again, Mr. Chairman, as I said, these are proposals. The bill before the House is a proposal, and the House is at liberty to clean it up, make further and or other provisions as the House may deem appropriate. The third issue was on the existence of the Housing Fund and the structures under the Housing Act, and whether there will be potential overlap, stroke duplication of functions with the enactment of the bill. On this one, Mr. Chairman, I know that the objective of the Housing Act is to provide for loans and grants of public monies for the construction of dwellings. In order to achieve this objective, the Act establishes the National Housing Corporation, funded through the National Housing Development Fund. On the other hand, the Affordable Housing Bill's objective is to provide a legal framework and a funding model in provision of affordable housing to Kenyans. We note, Mr. Chairman, that the Act and the bill complement each other through a structured way of giving effect to Article 43, Clause 1, Paragraph B of the Constitution, provides that every person has a right to access adequate housing and to reasonable standards of sanitation. Complementary. Nevertheless, Mr. Chairman, Section 7, Subsection 3 of the Housing Act does not provide for the source of funds of the National Housing Development Fund to include allocations from the Affordable Housing Fund. This would require consequential amendments to the Housing Act, in our view, Mr. Chairman, so that, in our view, there is no overlap and there is no duplication. Should it be required, should it become necessary, Mr. Chairman, that some of the funds from the housing, affordable housing can go to the housing, National Housing Development Fund, then that would have to occasion an amendment to the Housing Act to allow for that. Otherwise, as it is now, the funds under this levy cannot go to the National Housing Development Fund. So there's no overlap. Fourth question, Mr. Chairman, is whether the bill aligns with the Public Finance Management Act of 2012 with respect to the establishment of the levy and the fund. This is where I was making the distinction. Mr. Chairman, we all know that under the PFM Act 2012, under Section 24, Subsection 4, of that Act, it's only the Cabinet Secretary, the National Treasury, who may establish a national government public fund with the approval, again, of the National Assembly. Further to Subsection 4, Subsection 12 recognizes that a public fund may also be established through an Act of Parliament by providing that this section shall apply to all other national public funds, including funds earmarked for specific purposes established by an Act of Parliament. And to give an example of this, Mr. Chairman, is the Roads Fund under the Kenya Roads Act. There is one such fund. Indeed, Mr. Chairman, there is one that I know we created here called the mortgage fund, parliamentary mortgage fund, the car loans fund of Parliament. They are all created under different. Those ones are created under the Parliamentary Service Act. So this is what, in terms of what is provided for in subsection 12 of section 24 of the PFM Act. The salient principle that needs to be adhered to when establishing a public fund under the PFM Act or any other act is to ensure that mechanisms and structures are put in place to effect the prudent usage of the public funds in accordance with the Constitution. The bill, in this respect, proposes to establish the management board responsible for, inter alia, managing the fund and allocating monies as envisaged under Clause 11. Further, the bill proposes to designate the Chief Executive Officer appointed under Clause 12 as the accounting officer of the fund in line with Section 24, subsection 10 of the PFM Act. To this end, we are of the opinion that the establishment of the Affordable Housing Fund is within the meaning of the Public Finance Management Act, and that's a question that was raised in question 4. However, it is prudent to note that the provisions of Section 6, paragraph F of the PFM Act requires that where there is inconsistency with any other act of Parliament establishing a fund, the provisions of the PFM Act shall prevail. They take preference. It's important to note that, so that even in the event that any provisions within this bill may appear to contradict anything that is in the PFM Act, the provisions of the PFM Act will prevail. And I think for good measure, because I think the PFM Act, if you read the Constitution, is that act which is anchored in Chapter 12, which is a chapter on public finance in the Constitution. Finally, Mr. Chairman, you sought our view on the fact that the bill is silent on the procedures for the transfer of public land on which the affordable housing projects are built. And the question you asked is, how does the State Law Office propose to deal with this legal gap in the bill? Mr. Chairman, the State Law does not intend to deal with this. Our reaction to this is just to explain the salient features of both the Constitution and the Land Act. Article 67, Clause 2 of the Constitution provides that one of the mandates of the National Land Commission is to manage public land on behalf of the national and county governments. Further, Article 68, paragraph C, paragraph Roman 2 of the Constitution provides that Parliament shall enact legislation providing for the manner in which any land may be converted from one category to another. And this is important because if it is public land and it is designed, particularly in the context of this affordable housing, then the National Land Commission will be involved either by the national government, if the land belongs to the national government, or the county government, each county government, if the public land belongs to the specific county government, so as to convert from public into private use. The mechanism already exists. Article 62, Clause 4 of the Constitution provides that public land shall not be disposed of or otherwise used except in terms of an act of Parliament specifying the nature and terms of that disposal or use. On this premise, the Land Act was enacted by Parliament in 2012 to clearly provide for the mechanism to be applied. But, Mr. Chairman, I was surprised when I saw somebody crying that they have not been involved, because it is just the county governments and the national government who are supposed to go back to the provisions of the Land Act and involve the National Land Commission in acquisition of land and conversion of it from public to private. In fact, Section 9 of the Land Act provides that any land may be converted from one category to another in accordance with the provisions of the Act or any other written law, and that public land may be converted to private land by allocation. So the provision already exists in the law. Further, subsection 5 of that Section 9 provides that the National Land Commission may make rules that may provide for the substantial transactions requiring approval of the National Assembly, as the case may be, if it is land belonging to the national government, or the County Assembly, regulating and controlling the conversion of land from one category to another and the factors to be applied or taken into account in determining land that is to be converted, amongst others. In addition, Part 3 of the Land Act provides for elaborate procedures for the administration of public land, including leases, licensing, covenants, and conditions of leases and licenses, the buildings developed on public land, amongst others. Therefore, the provisions for the management of affordable housing units developed on public land, whether county or national land, are adequately provided for in the Land Act and need not be replicated in the Affordable Housing Bill, Mr. Chairman. I beg to submit.
Thank you.
That is the Attorney General Justin Muturi back to the familiar corridors of the August House, making presentation on the Affordable Housing Bill 2023. Of course, the AG raising pertinent questions and, of course, answering questions from the parliamentarians. It's a joint committee of that of housing as well as finance, talking about the financing elements as well as the availability of land and if they have adhered to the law in terms of the formulation of the Affordable Housing Bill 2023.